So the Supreme Court issued a new 6-3 decision in a case that's going to have huge implications for a bunch of cases, including 2A cases, like the Texas Suppressor Freedom lawsuit. So let's talk about what is now happening. As I mentioned in the intro, in this video, we will be discussing the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and ATF regulation of suppressors. Recently, the Supreme Court issued a new 6-3 decision which outlined that a universal injunction cannot be placed against a state's law. This order came in a case called Labrador versus Poe, and now it's being used to support the state of Texas in its attempt to defend their Made in Texas Suppressor Freedom law. This suppressor law is currently being challenged in a case called Paxton versus Dettelbach. This is an important and interesting case that has huge implications, and it was a case that was decided by a lower court, by a district court judge back, I believe, in last July, and it was decided on cross motions for summary judgment, and the case was dismissed by the lower court. Last July, the federal district court issued an order granting the ATF's motion for a summary judgment because the judge believed that the plaintiffs there lacked standing to bring the lawsuit. Also, the court found that the state of Texas could not stand in the place of their residents to sue the government to stop the application of the NFA towards Made in Texas suppressors. Texas appealed that ruling up to the Fifth Circuit, and the Fifth Circuit has recently heard arguments in this case and is set to rule on whether or not they believe the lower court was correct in throwing the entire case out because of a lack of standing. Now, if this case makes it out of the standing phase, what is likely to develop in this case is that an injunction will be sought by the Biden administration, likely to seek a universal block on the state's enforcement of their suppressor law. We saw the same thing develop in Missouri with their Second Amendment Preservation Act, and that case is currently moving forward. The Biden administration sought a universal block on that pro-2A Missouri law there, the SAPA law, but the Labrador case is currently being used by the state of Missouri to protect their state law from the universal injunctions that are being sought by the Biden administration. And the same thing is likely going to develop here with the Texas suppressor law. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that were made in and remain within the state of Texas. The claim behind this law is that since these items are made and sold exclusively within the state of Texas, they do not fall under interstate commerce, and therefore they also fall outside the purview of federal regulation by the ATF. Now, after the state of Texas passed this law, the ATF then sent out a warning letter, essentially threatening everyone in the state of Texas that they will still enforce the NFA and GCA's regulations against Made in Texas suppressors. So keep that in mind. This is a lawsuit that's still going on, and the ATF is still actively enforcing the NFA and GCA against these items. Well, the state of Texas then decided to sue the Biden administration and seek the actual enforcement of this law. This case was then submitted to a federal district court on cross motions for summary judgment. And then after reviewing the case, the district court granted the motion in favor of the Biden administration. So it went in favor of the federal government, and the state of Texas lost on cross motions for summary judgment. And the court there found in favor of the government under the rationale that the plaintiffs lacked standing to bring this lawsuit. Now, under the concept of standing, legal actions cannot be brought simply on the grounds that an individual or a general group is just simply displeased with what the federal government is doing or what the state is doing. Instead, there must be a bunch of standards that are met. Now, standing has 3 basic requirements, but the one that was here that was actually challenged and found to be deficient was an injury in fact. On review, the judge found that the plaintiffs have not suffered an injury in fact and therefore have no standing to bring this lawsuit. Now, here the judge essentially stated that the individual plaintiffs would have to allege that they either possessed an illegal silencer or that they have engaged in some other prohibited conduct that the ATF claims is illegal. The court also claims that the plaintiffs could show standing through the evidence that the ATF has actually directly threatened them, to enforce this type of federal law against Made in Texas suppressors that maybe they are in possession of. The judge also stated that maybe, in his opinion, they could cure this by going through the process, being approved or denied, and then at that point, well, then maybe they would have standing. Then there was also some dispute about whether the state of Texas could actually sue on behalf of their residents and whether the state of Texas itself had standing to bring this lawsuit. And again, based on all that, the judge found in favor of the federal government on a motion for summary judgment and then essentially dismissed the case in favor of the ATF. Now, in response, the state of Texas then asked for the Fifth Circuit Court of Appeals to reverse that lower court decision. The ATF responded to this appeal by saying that the Fifth Circuit should not even review this case and should simply uphold what the lower court said, that there is no standing. They also argued that under the Tax Anti-Injunction Act, or the AIA, This lawsuit was improper from the start and should not have ever even been filed. Then the ATF argued that the Second Amendment is also not implicated at all in this case because suppressors are not arms protected by the Second Amendment. The ATF stated that the Second Amendment's protection extends only to instruments that constitute bearable arms and that are typically possessed by law-abiding citizens for lawful purposes. Because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections. And according to the ATF, a silencer is a firearm accessory. It is not a weapon itself, and therefore the Second Amendment is not implicated. So again, the two main arguments for why the ATF believed that the Fifth Circuit should rule in their favor was first that the NFA's tax requirement implicates the AIA, and therefore this lawsuit was invalid because the individuals here, if they won, they would be avoiding paying a tax, which is required. And then they also doubled down on the position that, here suppressors are not protected arms, they're simply accessories, and therefore the Second Amendment is not implicated. In response to that, Texas pointed out to the Fifth Circuit that under the Supreme Court's 6-3 decision in Bruin, which struck down New York's concealed carry processing scheme, Texas and the plaintiffs here do have standing to challenge the NFA's process. They argue that post-Bruin, whether citizens may challenge requirements to apply for permission to exercise Second Amendment rights is an open question. Although the ATF cites these opinions as controlling authority from this court, it saves those arguments for last, surely because it recognized the shaky status of those opinions post-Bruin. Here, Texas is directly using the Bruin decision to point out that after Bruin, in a post-Bruin world, states like Texas and other individuals have the ability to challenge the application process in processes that are used as a barrier to the exercise of your Second Amendment rights. So here they're saying we are simply using Bruin to challenge a process, and under Bruin we can do that. The interesting thing with this case is that if it makes it past the standing phase, the next option for the Biden administration is simply for them to try to get a universal preliminary injunction to halt the entire enforcement of the Made in Texas suppressor law. Because again, if this case proceeds forward and makes it past standing, well then the question is this law in Texas back into effect? And likely what's going to happen is the ATF will try to get a universal injunction to halt the entire enforcement of the law. The Biden administration will seek that universal injunction, again, to halt that. However, under Labrador, that case identifies that that type of universal relief is in fact improper. In the Labrador case, the Supreme Court ruled in favor of the state of Idaho in protecting their law, and in that 6-3 opinion, the Supreme Court found that the district court's universal preliminary injunction was in fact improper. They also found and kind of told lower courts that they should no longer issue these types of universal injunctions. The Supreme Court focused on the fact that lower courts should in fact limit the scope of relief to just the named plaintiffs in the lawsuit instead of issuing broad orders that block states, at large from enforcing all types of laws against anyone. Now, the question going forward is, well, since the federal government, the United States, is a named defendant in the lawsuit, and then the state of Texas is also a named plaintiff, could the federal government get a broad-reaching universal injunction protecting them at large, the federal government at large, or against the state at large because they're a named plaintiff? Or could they only get it against the individuals? I believe there's one or two named individuals in the lawsuit. Would the universal injunction only go against those individuals? So it's a very interesting and nuanced approach that's happening right now with the state of Texas and their Made in Texas suppressor law. There are a lot of precedents that are being pulled in right now to try to overturn what is happening and try to protect the Made in Texas suppressor law. Right now, if you want to know what's happening, the Fifth Circuit, we are still waiting for a decision from them, but there's a lot of, different influence that is now happening, a lot of Supreme Court precedents that's being brought in, a lot of other court precedent that's being brought in to try to at least make it past the standing phase to see what now happens with the case going forward, because the lower court threw the entire case out, found that there was no standing. Right now, we're trying to get the case at least to make it past the standing phase so then some of these other things can develop. So that's what's going on right now. Again, a lot of nuance being brought into this. If anything else changes, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.